Our next submitter is Stace Hammond, and I understand Aaron Hunt is joining as well.
Good morning.
Good morning and welcome. We've got 15 minutes allocated for your submission this morning, but you might want to leave the committee members a bit of time for questions. As you can see, we've been quite useful to sort of have a bit of engagement with the submitter, so please leave some time if we're able to do that.
Will do. Thanks for allowing me to speak here today. I'm Aaron Hunt, partner at Stace Hammond, which is a law firm in Auckland. We've had the opportunity to act on a number of these matters under the civil jurisdiction within the court. My first one came into effect several weeks after the Act came into effect for civil proceedings, and we've been acting on a number since then, probably more so than any other firm in the country. I won't go through the Act as well, itself, because you're aware of the Act, neither will I go through the flaws that actually exist in the proceedings under the Act when it came into effect. It does need to be clear, though, that despite the intention of the Act under Section 1 to be this quick and efficient means of redress, the Act does not provide that under a civil proceeding. Instead, it goes through the typical civil proceeding of a court, which is a very expensive proceeding, especially if you are someone who is going through this sort of levels of harm. As an example, if you're looking to serve, like a lot of these cases, they are around anonymous content online, posts have been done online, or fake accounts without knowing who the person is that's posted it. And to try to de-anonymize those posts, if you're looking to go to a US social media company to try and get that information, you're looking at $1,000 to serve the court order to get the information and hope they respond. If you're looking to go to an Australian telecommunications company, it requires an action to be started in an Australian court to actually get a response from the company under the Act across there. So it is not an easy way for someone who has been harmed to go through this civil procedure. And that is the first reason why we're really strong to support this bill, because we've been through the proceedings for clients so many times through the court, often on a pro bono basis, because these people just often know they are often young, they're female, they are vulnerable, and they cannot afford a lawyer, let alone serving orders to different countries, starting actions in different countries. I did want to touch just quickly on the point of sort of the cause of the harm. And it needs to be very clear that, as I've probably heard from the previous speakers, that this is the sharing of intimate visual recordings is an extremely intimate thing. It is very much down to someone's, probably one of the most harmful ways of hurting somebody without being physical with them. It is intentional, it is international. We've had clients who have had fake accounts under their names on major platforms with thousands of likes and probably tens of thousands of views, and also being viewed by their family. You know, and these have been accounts with their names on, so identifying who they are with naked photos, videos, the worst things. And the first thing that they go to social media companies and they are great and the pages come down and they're created again under a new email account. It's too easy to redo, to repost with very little action against them. And the first thing first time they get any sort of word of about this process, they go to NetSafe say go to the police, they go to the police and the police say, yeah, you shouldn't have given that person those photos in the first place. Or by taking action here, it isn't going to remove the harm that's being caused. They then come and see me and I say to them, look, we'll do what we can, but it's going to cost this just for the filing fees in the various jurisdictions. There is no way they can afford the process to stop the harm. So that is why we do support this coming across and basically being by default under the criminal proceedings under the Act. We do believe there needs to be a few small clarifications to the bill. I think the wording around how consent is done, we prefer the method from a legal perspective, as seen in Section 22 of the Act, that sort of subjective, objective approach. Did they believe they had consent? Wouldn't a person in their situation, no ordinary person, believe they had consent? And that will hopefully remove most of the questions as to was consent there or not. We have heard talk, and I'm glad I've heard it, about deepfakes. So you're obviously very aware of what deepfakes are, because we see that as being something which is, well, you all carry cell phones, you can all make deepfakes, really. They're so simple to make. And that's something that will come through in the future, and the current wording of the Act does not allow for that. We believe there should be some allowance for linking to material as being bad as the original comment or original post. It brings attention to someone to the post, and it could be more harmful than the post itself. Someone creates an account and no one sees it, someone links to it and shares it to that community the person lives in, and that's where the harm is raised. And actually, that was it. Actually, I wanted to think everything else has been covered so far. As I said, we're coming from a different perspective than probably most of your speakers, in that I'm coming from someone who goes to court to try to aid these people. So I can't comment on how they experience harm or how you stop it in the community. I'm just there to try and stop, I suppose, hold people to account so they don't go and do it again and again. And there is sort of some response that I think is justifiable against the harm they are intentionally causing.
How do takedown orders operate from your point of view, and could they be made more effective?
They operate actually very well. I must say haven't had a situation where the social media company or the company involved that has the page up hasn't removed it on being notified of it actually existing. So we haven't had to have the court say to that company, take it down. If they don't do it straight away, NetSafe often gets involved and says, hey, get this done, can you please? We've gained contact at the lawyers for Facebook and Instagram, get on really well in California, and often saying to them, the post here, can you have a look at that? And they'll give it action pretty quickly. So the orders of the court itself that it can give under the civil proceedings are generally not actually needed by the point that you get to where it would give them, because the social media companies have already taken it down because they don't want to be drawn into any sort of action.
What about different platforms like Pornhub? Do you have much experience in terms of getting them to take down?
I haven't dealt with Pornhub previously.
Right. Okay.
Yeah, I have spoken with people in the sex industry who have concerns about their videos from, say, one site being used in another. And I actually mentioned that sort of passive consent. That consent should not be in any way assumed or inferred from it's on this site, so you can put it somewhere else, or show it to my family or my friends, or that sort of thing.
I don't know.
So my question for you was about that. How would a porn industry site make a case that under the new regime that's proposed, it would be quite easy to make out a case that if your video had been shared to free sites and wasn't behind your paywall, that there was a consent issue there? Wouldn't you take a case like that?
On behalf of, I'd have to by law. I'm a lawyer, so I have to act on either side. But yes, I think in that situation, if a porn site was going to have a video up, then if I was a lawyer, I was saying you'd be having written consent for that. And while I was listening to you before, when I was sitting in the back, listening about the whole written consent situation, I was thinking about that. If it was a commercial company, I would be surprised if there wasn't a belief that they should have had consent in writing before they put a video up. I think that would fall under would someone in that situation sort of believe they had consent? Well, yes, if they had it in writing, if it was a commercial enterprise.
Yeah. Dr. Smith.
My question is about the issue of consent. And where I'm interested in understanding the detail of the law are your proposed amendments on page 3 more restrictive or more liberal than those in the bill before us? That is, the bill before us says that the consent is given voluntarily and full knowledge of how the intimate recordings will be used. And your proposed wording on page 3 is different. Now, I'm trying to get an idea as to, on the one hand, I'm attracted by your wording. In the language you use is that any ordinary reasonable person in their position. But I'm also concerned in the sort of cases that you're practically dealing with as to sometimes there's an advantage in the law being quite specific and black and white about it. So yeah. I'm interested in your commentary. Is your proposed wording going to make consent easier or more difficult? And the rationale for why you think it is better than what's in the bill?
I don't think our wording is more liberal or not so. I think it seeks to clarify so that if someone was going to be in court and trying to argue whether they did or not or didn't have consent, they need to show that they believe they had consent, that it was expressed consent to them, and that somebody in their situation would have that same belief. Because consent, I know the original one did have sort of expressed consent, but someone could take that expressed consent in different ways. I could hear someone say something and say, oh, that means that I can do this, because in my view, that means expressed consent.
Correct.
But that's why we have the ordinary person test, would ordinary person in that situation believe the same thing?
The only thing I feel is that your amendment is going to make it harder for the victim to be able to argue that they didn't give consent, because it gives quite a lot of scope for if the language is an ordinary person reasonably believes that they would give it consent. To me, that's giving more case for the person who has put up the video to say, well, I thought they had, you know.
They have to provide something to base that,
Exactly.
that
Yeah,
belief
well,
on.
I think we need to write the law on the basis that actually you have to be, before you go post such an intimate recording, you've got to be really sure that the other person's given consent.
I think the problem is, if you don't mind me intervening, is that unless we have something in writing, then it is going to be an assessment based on behaviour of some sort, whether it's a nod or explicit wording, and therefore you need some sort of interpretive guidance, whether it's, as you say, subjective or an objective standard in terms of how you're interpreting that. Am I correct on that ground? So what you're suggesting is more of an objective standard.
It's
Subjective,
both. It's both a subjective
both.
and objective standards. So it's a subjective belief that person believed that, and objectively would somebody, an ordinary person in the same situation,
Also
believe
believe
they
that
had
as well.
consent.
Right.
What I'm saying is, I'm worried yours is a bit vague. I'm worried when the next client, if we pass your law, turns up.
This is a very common wording in a lot of different legislation.
It is.
It is.
And it's used as a test in a number of different areas.
It is absolutely, I mean, it is the point in a rape case often.
Exactly.
This is something we talk about. I'm absolutely delighted though to hear that you're going to give a little bit more to the complainant's view without the reasonable consent. In a rape trial might change, Mr. Smith.
Look, I would not purport to have any expertise in that area,
Mm.
in that area of law. So you shouldn't purport to go there. I think on the issue of intimate recordings, the presumption should be in favour of pretty explicit consent.
I actually think the subjective objective test is one that could work here, and I think it's a good suggestion, because we do have to think about the person on the other side of that camera, and their rights are also important. So, and while I see it's open to abuse, because I've spent a lot of years in sexual violence casework, I think it is still important. It's an interesting suggestion.
It is, and I also think it helps address a problem which a number of submitters have raised, which is young people who may also be offenders, and just getting the context of some of their behaviour as well. And while I've got the mic for a moment, did you have comments on withdrawal of consent?
Oh yes,
Yeah.
I actually hadn't commented on that. Well, I haven't written this, but the withdrawal consent will end the consent. That should be the default. Consent no longer exists when it has been withdrawn. So at that point, you cannot use those images. Those images should be used and shouldn't be used. In the same manner that, I suppose, in any other area, if the consent is given and then withdrawn, then that consent is no longer there.
How do you get on with the legal situation where someone has been involved in a commercial business, say producing a lawful porn product? They give their consent. If you give them the right to withdraw that,
it's a contract.
Their contract that states that there's no right there to withdraw the consent because they've got a contractual agreement.
and this law would make plain that such a lawful contract would override the withdrawal option.
It wouldn't need to, I think, go to state that because they have provided that as a service in exchange for a fee, and that contract would clearly state that they give their consent and they waive their rights.
Consent is within the contract.
It's problematic though, because withdrawal of consent is, you know, this is criminal law we're talking about, not civil. And, you know, so what is the person who took the video and the other person who's the complainant, if you like, says, well, I withdraw consent now, but it's up in Germany now, and sorry to be so blunt in relation to a delicate matter, but the chicken's flown the coop, and we're criminalising that.
Well, We're not, because we're not, if it's been on posted, we're not criminalising them for the on post, we're criminalising them for their post. And that's what the Act states.
But that then there's a problem for the victim because, and that's what we've heard in submissions,
Yeah.
particularly some of the anonymous ones, is that they've spent years and years trying to trace down a video clip that's been subsequently shared or reposted or modified in some way.
So you can have action against the original poster, but any post after that, if they did withdraw consent and they removed the original post, it is outside their control if that video has spread.
Yeah, so
I
what
think
they can
you
do is
can't
copy
punish them
that
under the Act
video.
on that.
So what essentially could happen is if there's two parties, one's provided consent, the video's been uploaded to the internet, subsequently that consent's been withdrawn, the original party to that has taken it down. But what you don't know is that that could have been downloaded by
And most
other
likely it was.
parties, and therefore there's no consent and there's no way of tracing.
I guess you would then be left with prosecuting the downloaders on the basis that they didn't get consent for the or
Well,
the third party on
platforms.
sharers.
So Lewis's argument when she presented earlier was that the platform should hold some accountability, but that's obviously beyond the scope of, well, both the bill and the law possibly.
Yeah.
But that there should be guidance for those platforms to replicate what Facebook have in
Yeah,
place.
those platforms are, most of them are reasonably good. The larger ones are, because they realise the issues they would have in certain jurisdictions if they kept these things up. So they do act very quickly on being notified of bad material. But there are other platforms which are just as hard to touch.
Yeah, and they pop up and go down, no doubt.
They do.
Any other questions, members?
And one quick point on Honourable Bridges stated. Our belief is that this should actually be appearing in the Crimes Act, the offence of this. It seems to be, and being an inside act, some of my colleagues I've spoken to about it have sort of almost seen it as being a less major thing. You know, it's only a small, it's an inside act, it's not a crime, you know, they might go to jail for this. It's like, well, they probably should in some of these cases. So the fact that it's not in the Crimes Act, should still be a crime with severe penalties if it has been posted and they have done it for the intention. You know, it creates major stress. You know, when I've got a young lady in front of me talking about her suicidal intentions because she's gone through lockdown and her posts about her, it is horrific.
I think what it requires though is a broader look at the criminal penalties across the board in this area. So it's we've got to move with the times, but unfortunately with the members bill, I don't know that that's something we will be able to fix.
Can we, with this bill, make it a crime?
We can.
Well, it will be, but this will be a crime.
The bill is harmful digital communications now, so you're adding
top dog of
Crimes Act.
criminal laws, which is the Crimes Act.
Unfortunately, this isn't amended crimes.
What was your, sorry, I know you did it and I was out,
Creating a new
but what was
offence.
your basic position on what we should be doing about consent?
Going to the subjective objective view that we have under the main act in section 22 for other parts of it.
You didn't have anything to say about whether it would be whether this sort of debate we've had, a discussion we've had about it,
Proportionality.
wanting sort of written consent. That would merely be a matter of evidence.
Yeah.
Yeah.
If someone had a video of consent, it wouldn't strictly be written consent, but I think that would be just as good as written consent. So I think it should be looked at the situation as to what the consent is, how it was given, and the reliability of it. If someone gave a drunken written consent, you couldn't say they written consent. So,
What provisions currently exist within the Crimes Act to prosecute in this space?
well, I'm not a criminal lawyer, so no, I can't really comment on that. There is, from memory, there is nothing really. There is taking of an intimate visual recording without someone knowing is a crime under the Crimes Act. Here, when they've knowingly done it, it's not under the Crimes Act, and that seems to be a strange situation. You know, if you record someone without them knowing and no one else sees it, it's a crime under the Crimes Act. Here, you publish it internationally, and it's not. So.
Thank you. That was very useful, really useful. Yeah. And thank you for representing people who need help in this space.
And I do wish we'd had time to get into the reverse onus debate, but thank you for raising it in your submission.
All right, thank you.